Hello everyone, welcome to my channel. Do you know what exactly law is? The topic for today's discussion will be about law, its meaning, definition, and other explanations. So, at the heart of the legal enterprise lies an important concept that is law. Owing to societal inclination of interest in favor of business, it is essential to understand the basics of law for everyone. Without an understanding of the concept of law, the orientation and motivation towards attainment of justice is found missing. Let's move to its nature and meaning. We can see that there has been many jurists who has described the nature and meaning of law. However, there has been no unanimity of opinion regarding the true nature and meaning of law. The reason for lack of this unanimity on the subject is that the law has been viewed and dealt with by different jurists so as to formulate a general theory of legal order at different times and from different point of views. That is to say, from the point of view of nature, source, function and purpose of law to meet the needs of some given period of legal development. Therefore, it is not practicable to give a precise definition of meaning of law, which may hold good for all times to come. However, it is desirable to refer to some of the definitions given by different jurists so as to clarify and amplify the term law. The various definitions of law propounded by legal theorists serve to emphasize the different facets of law and build up a complete and rounded picture of the concept of law. In this video, we will refer to some representative definitions and discuss them one by one. For the purpose of clarity and better understanding of the nature and meaning of law, we may classify various definitions into broad classes such as natural, positivistic, historical, sociological, and realistic. First, we have the natural school, also known as the idealistic school. Under this falls most of the ancient definitions given by Roman and other ancient jurists. Alpine defined law as the art and science of what is equitable and good. Caesarius said that law is the highest reason implanted in nature. Justinian Digest defines law as the standard of what is just and unjust. In all these definitions propounded by Romans, justice is the main and guiding element of law. Salmond, the prominent modern natural law thinker, defines law as the body of principles recognized and applied by the state in the administration of justice. In other words, the law consists of rules recognized and acted upon by courts of justice. It may be noted here that there are two main factors of the definition given by Salmond. First, that is to understand law, one should know its purpose. Second, in order to ascertain the true nature of law, one should go to courts and not to the legislatures. Also, Vinogradov described law as a set of rules imposed and enforced by society with regard to attribution and exercise of power over persons and things. We all know what ancient Hindu view says, that law is the command of God and not of any political sovereign. Everybody, including the ruler, is bound to obey it. As the Gita says, law is a part of dharma. The idea of justice is always present in Hindu concept of law. The another set is the positivistic definition of law. Herein, John Austin defined law as the aggregate of rules set by man as politically superior or sovereign to men as political subject. In other words, law is the command of sovereign. It obliges a certain course of conduct or imposes a duty and is backed by a sanction. Thus, the command, duty and sanction are the three elements of law. Kelsen gave a pure theory of law. According to him, law is a normative science. The legal norms are ought norms, as distinguished from is norms of physical and natural sciences. According to Kelsen, law does not attempt to describe what actually occurs, but only prescribes certain rules. The science of law to Kelsen is the knowledge of hierarchy of normative relations. All norms derive their power from the ultimate norm called Grundnorm. Now, by the help of historical facts, there have been certain definitions of law. According to Savigny, the theory of law can be summarized as follows. Number 1, that law is a matter of unconscious and organic growth. Therefore, law is found and not made. Secondly, law is not universal in nature. Like language, it varies with people and age. Third, custom not only precedes legislation but is superior to it. Therefore, law should always conform to the popular consensus. Fourth, law has its source in common consciousness of the people. Fifth, legislation is the last stage of lawmaking and therefore the lawyer or the jurist is more important than the legislator himself. Also, in the historical definition given by Sir Henry Maine, the word law has come down to us in a close association with two notions, that is, the notion of order and the notion of force, according to Maine. We also have the sociological definition of law given by Aaw.It, wherein he defines law as essentially and exclusively a social fact. Also, herein defined law as the form of a guarantee of conditions of life society, assured by state's power of constraint. There are three essentials of this definition. First, in this definition, law is treated only one means of social control. Second, law is to serve social purpose. Third, law is coercive in nature. Also, the famous Rousseau Pound said, law as a social institution to satisfy social wants. He analyzed the term law in the 20th century background as predominantly an instrument of social engineering in which conflicting pulls of political philosophy, economic interest, and ethical values constantly struggled for recognition against background of history, tradition, and legal technique. Rousseau Pound thinks of law as a social institution to satisfy social wants because the claims and demands and expectations involved in the existence of civilized society, by giving effect to as much as may be satisfied, or certain claims can be given effect only by ordering of human conduct through politically organized society itself. Also, there is a realistic definition of law, wherein law is defined in terms of judicial process. According to Holmes, law is a statement of the circumstance in which public force will be brought to a bear upon through courts. Also, according to Cardozo, a principle or rule of law to conduct so established as to justify a prediction with reasonable certainty that it will be enforced by court if its authority is challenged is a principle or rule of law. From the above definitions of realistic jurist, it follows that law is nothing but a mechanism of regulating the human conduct in society so that a harmonious cooperation of its member increases and thereby avoid the ruin by coordinating the divergent conflicting interests of individuals and of society, which would in its turn enhance the potentialities and viability of the society as a whole. To summarize, there are certain elements of law which needs to be there in order to become a definition of law universal. The first is that law presupposes a state. This means that there cannot be any law without a state. The second, the state makes or authorizes to make or recognizes or sanctions rules which are called law. Thirdly, for the rules to be effective, there are sanctions behind them. Such sanctions can be in form of punishment or damages. Further, these rules can be made to serve some purpose. The purpose may be social or any other need of personal choice. So, separate rules and principles are known as laws. Such laws can be defined in three categories: mandatory, prohibitive, and permissive. A mandatory law calls for affirmative act. Example, as in the case of law requiring the payment of taxes. Further, prohibitive law, which requires negative conduct, as in the case of law prohibiting the carrying of concealed weapon or running a lottery even. Thirdly, a permissive law, which is neither required or nor forbidding any action but allows certain conduct on the part of an individual if it desires to act upon. So, how can you say the laws are effective? Number one, by administrating some form of punishment or preventing disobedience, or even by requiring, in some instances, to complete an obligation he has failed to do, as in the case of specific performance of act. Also, by requiring damages to be paid for an injury due to disobedience. The law and the system through which it operates has developed over many centuries into the present combination of statutes and judicial decisions, customs, and conventions. By examining the sources from which we derive our laws and legal systems, we gain some insight into particular characteristics of our laws. So, the state, in order to maintain peace and order in society, formulates certain rules of conduct to be followed by people. These rules can be called as laws. This was it for this video. See you in the next video. Till then, bye bye.